We just have the one final case also from Cedric County, 128-305, the state of Kansas versus Thomas Eugene Brown. Any comments?
Mr. Brown actually is here in person. He is appearing by counsel, Wendy Miller.
And the appellee.
May it please the court, Robin Summer appearing on behalf of the state of Kansas.
Ms. Miller, do you wish to reserve any time for rebuttal?
3 minutes, Your Honor.
That is granted, and you may proceed.
Well, we're here today to talk about quantity and a motion to correct an illegal sentence. Mr. Brown was convicted of 1 count of possession of heroin with intent to distribute. As far as sentencing, the district court found that there was a balloon of marijuana in Brown's car, that his coat pockets were searched at jail, where there were balloons of heroin found. Now, the district court found that the amount was over 3.5 grams.
I thought he was convicted by a jury.
He was.
Okay, so a jury did convict him for with possession of heroin with intent to distribute
Yes.
for that amount. The jury made this finding of that amount of from 3.5 to 100 grams of heroin. Is that correct?
Right.
So this is a jury's finding.
And this is at sentencing that I'm discussing what the district court's findings were as far as the quantity.
But the judge, the disconnect that I see with your argument is we're ignoring the jury's verdict. The jury's verdict doesn't change from the time they reached the verdict to sentencing. The jury convicted him of 3.5 grams to 100. We don't get to go back and reweigh the evidence at sentencing. Is that correct?
Right.
So we don't upend a jury's verdict. And I'll give you a hypothetical. Let's say Bonnie and Clyde are robbing banks. Okay, they're going through Oklahoma, Texas, and Kansas. And they rob 7 banks. A Bonnie and Clyde type, present day, and they do a ballistics on review of 5 of the 7 banks. Okay, and the ballistics show that the casings left from the bank robber line up the defendants from 5 of the 7 banks. Okay, so we have definite proof that they robbed 5 of the 7 banks, but they're charged with 7 because of other evidence that comes in besides the forensics evidence. Okay, under your theory, the jury convicts them of all 7. Under your theory, should they only be sentenced for 5 of the 7 banks?
Well, I think in this case, and what we've cited in our reply brief is we referred to the Lay case. In that case, as I looked over it again, I feel like that case is significant here because that case, the court says that drug quantity is not an element of the crime of conspiracy to distribute marijuana. Now, that case is dealing with distribute marijuana. This case is dealing with distributing heroin. But it's still 21-5705. And that case discusses that drug quantity was relevant for sentencing purposes. So I think the judge could, in sentencing him, look at the quantity and find that the evidence at trial showed that it was under the 3.5 grams.
So now we're having a judge do the fact finding that could increase or decrease a person's sentence. Are we getting into the Apprendi territory?
And that's a good question.
Because I'm concerned. That's why I keep on going back to what did the jury find?
Right, and you're right about that. You're right about the jury's findings. But what the argument is, what the argument he's making under the statute is that the particular part of the statute that shows that somebody's guilty of a level 2 is there has to be 3.5 grams.
Right.
And so his argument is that the lab report showed that out of the bags that were tested, it was under 3.5 grams.
Right, but there was, I'm sorry, good question.
Oh, go ahead.
But there were over eight grams found, correct?
Well, the balloons, everything was weighed, but not everything was tested.
Right, and that was my hypothetical about, you have 7 banks, but you only have certain testing, not of all. Do they, and so here. They chose to test not all 8 grams, but they tested sufficient amount. Correct.
They did a sampling, because there was more than 10 items. The expert said he did a sampling. And out of, they selected these balloons that contained a substance that they were testing to determine whether it was heroin. They randomly selected 18 balloons out of these 40+ balloons and tested those, and each of them did test positive for heroin. But the other balloons were not tested. So there was only 18 balloons tested and almost 30 other balloons that were untested. We don't know what was in the balloons. And then everything was weighed, is my understanding. And then that's how we come up with the 8 or 9 figure. So what Mr. Brown's argument is that with not testing these items, we don't know what's in it. So the jury was called to speculate by the state in finding that there was 3.5 or greater. It was guesswork.
My question is much broader than any of this discussion. You're trying to reverse his conviction based upon insufficiency of the evidence. What's that got to do with correcting his sentence? That's what this appeal is, from a motion to correct an illegal sentence. How did he get an illegal sentence?
Well, what we're saying is that the quantity that was proved at jury trial was less than 3.5 grams. And so then in sentencing him to the level 2, for which there has to be 3.5 grams, that's where the illegal sentence provision comes in, is because it doesn't.
Isn't there case law that kind of spells out pretty clearly that this does not fit within an illegal sentence claim under 22-3504?
Well, and we talk about the McAdam line of cases, and under Harb and Swisher, where folks were saying that they should be sentenced on a lesser offense where you had 2 statutes with identical elements. But I think what's different about that line of cases is that here we're talking about what penalty to impose based on the weight. And I'm relying on the State versus Lay case that indicates that drug quantity is not an element of the crime of conspiracy to distribute marijuana. I think likewise, it should not be considered an element of the crime here. So if we just look and isolate the penalty provision of the statute, then his sentence did not comply with the applicable statute if there wasn't a quantity of 3.5 grams or greater. So that's really the argument. We've made an alternative argument in our case too, that if the state is correct, and this is really a sufficiency of the evidence argument, then the court could look at remanding this case back for treatment of this case as a 1507.
Why would we do that? I wanted to talk about that. Why are we making an assumption by saying this should be remanded for something? Or we assume that there's error by the district court counsel?
So if the court views this as a sufficiency challenge, then really his motion should have been construed under 1507 as the argument. Now, he may have procedural hurdles that he's got to get past. He's still gonna have to get past the 1 year time limitation and show exceptional circumstances, which We cite the Swisher case. In that case, I believe the court found exceptional circumstances. And I think they did that based on an attorney's representation through a letter. That there were exceptional circumstances for that issue being raised, and then the court remanded it for a hearing. And so we would say that if it is determined by the court to be a sufficiency claim, then it really should have been construed as a 1507 and then remanded to the district court for consideration under 1507 and whether he can meet the time limitations.
What would be the theory under the 1507? I'm not following
If it's viewed as an attack on his conviction, as opposed to an illegal sentence claim. Our position is that it is an illegal sentence, because it involves the penalty provision of the statute that he's provided in his brief, and that this is an illegal sentence.
But if it's a 1507, it would be a remand alleging ineffective assistance of counsel for not arguing
Right,
insufficient evidence on the direct appeal.
that's correct.
I'm gonna revisit the question that Judge Pickering asked you way up front. When the jury found him guilty of possession of heroin with intent to distribute, were they asked on what basis or the drug quantity was? Or didn't you say the jury found him that he distributed between 3.5 grams and 100 grams? The jury found that?
Well, and I would have to look at the record to be sure of that. I know that in arguing and closing, that the state indicated they had to prove that there was 3.5 grams. And that was part of Mr. Brown's argument, was that the state had indicated, that the jury should leap to this conclusion that there was 3.5, even though not all of the bags were tested. That the jury should just decide that this was how much there was, even though nothing had been tested. And so Mr. Brown's argument was then that the jury was asked to speculate on the quantity. So, but in looking at the Lay case, that analyzed the same statute, a different substance, but the same statute, to me, that case almost stands for the proposition that it wouldn't matter whether the state proved 3.5 grams to the jury or some other amount, because the penalty provision of the statute, and that is what you're sentenced for. On a level 2, you would have to have 3.5 grams. But that 3.5 grams wouldn't necessarily needed to be proved. If you look at the Lay case, that finds that drug quantity is not an element of the crime of conspiracy to distribute. So going off of the Lay case, that I think fits with the argument that this should be construed as a motion to correct an illegal sentence, and that it is an illegal sentence, that he was sentenced for a level 2. Should have been sentenced for a level 3 because the evidence at trial did not support a level 2. And that's what we're requesting the court to do, is find that his sentence was illegal, that the quantity wasn't proved, asking the jury to speculate is prohibited. We don't know what was in the bags, if anything, that were not tested. We have an amount that was under 3.5 grams, and then we're sentencing him for a level 2 that requires 3.5 grams while we don't know what was in the bag. So I would ask the court to find that he did receive an illegal sentence, and that the jury can't speculate on the amount. If the court does find that this should have been construed as a sufficiency claim, then the court has the option to remand for the court to consider this motion as a 1507 and whether counsel was ineffective. And if there's no other questions.
May it please the court, Robin Summer, Assistant District Attorney appearing on behalf of the state of Kansas. There is no way that you can give the defendant the relief that he is seeking without disturbing his conviction. This is a sufficiency of the evidence argument, which is not allowed in a motion to correct a legal sentence, which is what the defendant filed his motion under. In this case, the defendant was convicted of possession of heroin with intent to distribute level 2 drug felony, as well as possession of marijuana and traffic infraction. After conducting the traffic stop, the defendant was arrested and 48 balloons containing suspected heroin were found in his interior coat pocket. The contents of the balloons were tested by the Forensic Science Center, where testing confirmed that the balloons indeed contained heroin. The chemist testified that the lab had a policy of random sampling, and they were provided more than 10 items that appeared to be the same. They do a test, and they explain the scientific reasoning behind it and how they get there. It goes into square root of the total to get a statistically representative sample of the whole. So in this particular case, 19 of the balloons were tested. And all of them, testimony was all of the balloons were packaged in the same way. They had a similar size, similar characteristics. And 18 of the 19 balloons tested positive for heroin. In addition, the weight of the balloons that were tested positive came to 3.29 grams. But the net weight of all the balloons together, I counted up and I believe it exceeded something around 27 grams of all of the balloons together. The state argued in closing that the jury could consider and make reasonable inferences regarding all of the balloons together, that the balloons were found all in the same location, that they're similarly packaged, that they have similar appearance, similar size, similar characteristics, and that the jury can make a reasonable inference as to whether the state had met its burden, that the total weight exceeded 3.5 grams.
So that answers the earlier question, Judge Garner, of how much was the jury asked to find a certain weight of the drugs, is that correct?
Yes, and the only issue with regard to the heroin that was before the jury was the charge of 3.5 to 100 grams. The defendant elected to not ask for a lesser included that would have been a severity level 3, that would have been 1 gram but less than 3.5 grams. His counsel was very clear in jury instructions that he did not want a lesser included. He wanted to go to trial on the level 2 and only the level 2. And so the only issue presented to the jury was there 3.5 grams of heroin or more? And the jury clearly found that there was 3.5 grams or more because they convicted him of that count. And so now the defendant is asking to be sentenced on a level 3, when at trial, he was like, no, I don't want the jury to even consider a level 3. But he's now coming back these years later and saying, hey, I want to be sentenced at the level 3. He wanted an all or nothing trial, and that's what he got. And he was convicted of the level 3 or the level 2, the jury clearly finding the level 2.
Was any of this raised in the direct appeal? Just out of curiosity.
Defendant's claim on direct appeal was the district court erred in not giving a lesser included to the level 3. And this court found that that was invited error. Because the defendant was very clear in his statements at the trial that he did not want the level 3, that he was not asking for a lesser included, that he wanted to go to trial on all or nothing. And there was no he could not raise sufficiency of the evidence on the direct appeal either. With regard to the claim that this should be alternatively construed as a 60-1507, the state's position is that this is untimely by multiple years, even if you factored in COVID time. The mandate was of the direct appeal was filed in 2020. The motion to correct a legal sentence was filed in 2024. The state's position is that the defendant has not made any argument regarding manifest justice. And even if there was a procedural time bar waived, this is trial error and not appropriate to be raised at 60-1507. And there has not been argument that it was that his trial counsel was or appellate counsel was ineffective for not raising sufficiency of the evidence at the direct appeal.
If they had, I'm gonna ask you to speculate. If they had raised insufficiency of evidence in direct appeal, it would probably lose. Would you agree with that?
I would agree,
And why?
because it is an issue of invited error.
Well, no, I meant, even if they said, oh, insufficient evidence for over 3.5 grams, there was still sufficient evidence to support the finding out that he was carrying.
Absolutely. I mean, there was all the evidence regarding the location of the balloons, the size, the weight, that it's not a wild speculation to come to the conclusion that the total number of all of these balloons contained heroin, considering that the random sampling shows that 18 of the balloons that were tested contained heroin. So it's not a huge leap to go. The rest of them probably did as well.
Right, it would have been different if they tested 18 balloons and half were heroin and half were not. Then you're entering a question of uncertainty, but here, all of them were tested positive, is that correct?
All 18 of them did,
All 18
yes.
that were tested, every single one came back heroin.
Correct.
Maybe you can help me with something I'm thinking about, because, the Apprendi issue sort of underlies some of this, because it seems like, that the Lake case says, correctly, that normally the quantity of the drug isn't an element in proving the crime. The crime is, possessing with intent to distribute. Oh, what amount? And so now what you're doing to get around Apprendi is to charge a certain severity level or drug quantity as part of the charge and as part of the verdict form. Do you find this was met beyond reasonable doubt? Check yes or no. Is that the way you're doing it?
I can't speak for, I guess I can't speak for the generalities of it. In this case, I believe that in the record will speak for itself as far as how the jury instruction was written, but my recollection was that the state had to prove that there was 3.5 grams or more up to 100 grams in order for the jury to be able to convict on this count. And so that was what the jury was faced with addressing. And so the weight was included as an element in this case. And again, the record would speak best for that, but that is my recollection.
And conspiracy to distribute is quite different, right? In terms of weight, because you're looking at the conspiracy part, the group agreement to distribute drugs.
Yes, I think that has additional elements rather than just and the statutory requirement here was if it was 3.5 or greater, it was considered distribution amount without needing to have evidence of other elements for conspiracy, but just the mere possession provided a rebuttable presumption that that was distribution. If there's no further questions.
Your client is still serving this sentence, right?
He is on post-release,
Okay.
yes. And really, the only thing that I would finish up by saying is that I believe that if the sufficiency was looked at, that it wouldn't be sufficient. Because we've got such a small amount of a drug. And I'm not an expert on drugs in any way, shape, or form. But when we're talking about 3.5 grams, that's a pretty small amount. I don't know that you could just look at an item that contains whatever amount of this substance and decide, oh, well, it looks the same as these other balloons that were tested and these balloons all tested positive. So I don't think it's as cut and dry as that. I don't know if the balloons were taken. It's my understanding that they were in a sandwich bag. I don't know if they were taken from the top of the sandwich bag. There's a lot of room for question. Because we don't know what was in the bags. So that's more of a leap, I think, than could be made on the sufficiency. And with that, I'll submit this case for your consideration. Thank you.
All right, counsel, thank you very much for your briefs and your arguments. We appreciate it. We'll get a written opinion out to you just as soon as we possibly can. And with that, court is in recess until 1:30 this afternoon.
All rise.